Welcome to Oil and Gas. Today we're going to talk about all the complications that can come up when you try to sell land that already has a lease on it. And the first thing that we're going to talk about is what happens when you try to make clear that you're selling land that already has a lease on it. Now, normally, when you do that, you want to make clear the land you're selling is subject to a lease. So they're not getting the land free and clear of any lease with the ability to do anything they want with the minerals. It's already leased to an oil and gas company. And so that lessee has a lot of control over the land. But usually you also want to say all the benefits that came with that lease that went to the lessor are transferred with that as well. So typically you want to say that it is subject to that lease that you're transferring, but it also covers and includes all the lease benefits from that. And how you do that can be quite complicated and create some interesting legal problems. So let's talk about this. Subject to clauses. What happens when you're trying to convey leased land? As I suggested, typically it's going to have this clause that says it's subject to the lease, and it also covers and includes the lease benefits. The idea here is that you want to protect the grantor against claims that they're breaching their warranty, because the idea is if you sold that land, the grantee would have thought, hey, I can develop the oil and gas minerals as much as I like, particularly if there hasn't been development yet. But if it's in fact in a primary term, there's some oil and gas company that has the exclusive right to produce oil and gas on the land, obviously that's something you need to tell your grantee. But often when you have this mineral deed, you want to also say, well, what happens with the lease benefits? Do they keep going to the old owner of the property, or do they go to the new owner of the property? So does it cover and include those lease benefits? Those can sometimes create some problems. So, in theory, this probably shouldn't be necessary. Our assumption should be that the lease benefits go with the land. But in fact, you'll see lots and lots of deeds that try and make that clear, and how they make that clear can sometimes create problems. So let's talk about some of the problems that it can create. So let's talk about this Hoffman versus Magnolia case. It's a 1925 case. Basically, in that case, there were 320 acres that had been leased to an oil company. Now, the owner conveys a 1/2 mineral interest in just 90 acres to Hoffman. Okay, so far, so good. Selling a 1/2 mineral interest in 90 acres to Hoffman, but said that subject to said lease. Okay, good. You want to let them know it's already been leased, but covers and includes 1/2 of all the oil royalty or gas rental or royalty to be paid under the terms of said lease. Okay, what's the problem? The problem is that what was conveyed was just 1/2 mineral interest in 90 acres, right? Just in those 90 acres. But the instrument says that it covers and includes 1/2 of all the oil royalty under the terms of the whole lease for all 320 acres. So you basically have this 90-acre half mineral interest, but it's giving 1/2 of all royalty in the full 320 acres. And the problem here is that oil is produced on the other 230 acres, and the court says, well, these are the covers and includes language literally says that you get 1/2 mineral interest in that full 320-acre lease. And so therefore Hoffman gets 1/2 of the lease royalty, even though the production is in the 230 acres not transferred. Okay, let's look at another case. And we'll see that the way that the Texas courts have decided these issues is not always consistent. So let's talk about this Concord Oil versus Pennzoil case. In this case, Crosby just owned a 1/12 mineral interest. Okay, at least that land for a 1/8 royalty. So he conveys a 1/96th interest in and to all of the oil, gas, and other minerals in and under, and that may be produced from the land. All right. So forget what Crosby owns for a second. What does this language describe? 1/96th interest in and to oil, gas, and other minerals in and under, and that may be produced from. What kind of interest is that? It's a mineral interest. It's got that in and under language, right? It's a mineral interest. Is it a 1/12 mineral interest? No, it's a 1/96 mineral interest. So if you just looked at the grant itself, you would say that's a 1/96 mineral interest. But then we go to the covers and includes clause, and it says, the conveyance is made subject to the terms of any valid subsisting oil, gas, and or mineral lease or leases on the above described land, but covers and include 1/12 of all rentals and royalties payable by the terms of such lease or leases insofar as they pertain to the above described land. Okay, now it says 1/12 of royalty. Okay, so this is Texas 1998. What does the Supreme Court make of this? Well, they say, plurality says, look, the idea was obviously to convey a 1/12 mineral interest. After all, that's what the grantor had. That's what Crosby had, was a 1/12 mineral interest. Okay? So they were trying to convey that 1/12 mineral interest, and it didn't make any sense to have a 1/96 mineral interest plus 1/12 of royalty. That simply doesn't make any sense. And so the court says the plurality here, controlling plurality, says, look, the deed conveyed what was owned, which is just that 1/12 mineral interest. So it conveyed all of that, wasn't described very precisely, but we're going to harmonize these two inconsistent provisions to mean that. Now the concurrence says, no. The assumption is wrong because the two grants would result in an overconveyance. Because if you look at the literal terms here, you have a 1/96 mineral interest plus 1/12 of royalty. Okay, that in effect, the 1/12 of royalty, basically for leased land, right? That's all you got left. If the bonus has already been paid, so that's basically a 1/12 mineral interest at this point. 1/12 mineral interest gets you 1/12 of whatever royalty is paid on that land. 1/12, by the way, is 8/96. So the concurrence says, basically, that would give you 8/96 plus 1/96, because it said it was a grant of a 1/96 mineral interest. So you add the 1 plus 8/96, that doesn't make any sense. And so for that reason, we're just going to have to go with that plurality majority result. So the court basically agrees the intent here was to give 1/12. By contrast, the dissent says, well, no, they literally conveyed more than they owned, but fine, we have ways of dealing with that. You can sue somebody for it. So the literal words convey 1/96 of minerals plus 1/12 of rent and royalties under the lease. So I'm going to go back to that and we can look at that. So the dissent says here, look, there was conveyed 1/96 interest. That's a 1/96 mineral interest plus 1/12 of royalty, or 8/96 of royalty. And even if that adds up to 9/96, and even if Crosby only owns 8/96, the literal terms promise 9/96, and Crosby should be liable for that. Okay, so you can see what you think about that. Now, what I want you to notice is, notice the little bit of inconsistency here between this Concord Oil and the Hoffman case. In the Hoffman case, the court basically just read it literally, even though probably what was intended was just a half mineral interest in just the 90 acres. The court says, well, you said half interest in the lease, and the lease covered 320 acres. So the court took it literally, and so maybe not what was intended, maybe it was sloppy draftsmanship, but the court interpreted it literally. Here in Concord Oil, the court says, well, we can tell what you meant, and what you meant is a 1/12 mineral interest. And we'll see that this kind of problem about how literally do we take the terms from somebody who probably didn't write this the way they intended is a recurring problem. Okay, another rule that now has basically been overruled, but is this idea of repugnant to the grant, which is, let's not look at the covers and includes clause if it is inconsistent with what the basic grant says you were giving. So if there is an irreconcilable conflict between the granting clause and some other provision, then the granting clause will prevail. Okay. So that's from this case, Alford versus Crum, Texas, 1964. Now I want you to, we're going to go back, I'm going to go back a slide and look at Concord Oil versus Pennzoil. What's the grant here? The grant is that first conveyance, 196 mineral interest. Okay? The covers and includes clause is inconsistent with that. So under Alford versus Crum, you would think, okay, we go with actually a 196 mineral interest. So that's what the repugnant to the grant rule would say, that you'll sometimes hear people talk about, is that we prioritize what the grant said. As you can see, the court did not follow this in Concord Oil, and so that's no longer the rule, but sometimes you'll hear people talk about it. So let me go back, Alford versus Crum. It was actually overruled in a case that your book just talks about a little, Luckle versus White, and I'll explain that case. Basically, the new rule that you see in Concord and Luckle is this idea that we're going to harmonize the four corners of the deed, try and figure out one reading of them that's consistent and makes sense. And we'll see that sometimes that's a little bit unsatisfying. Basically, we're trying to take an apparent conflict, review the four corners of the instrument, and try to harmonize them. We can see how it might work in Luckle versus White. There's also this case, a similar case, Highsaw versus Dawkins, which is talked about on page 613. In that case, what was granted was 1/3 of 1/8 royalty. It's a little confusing. The court determines that that means 1/3 of lease royalty, since 1/8 was often the assumption about what a lease royalty would be. Okay, let's talk about Luckle versus White. So in that case, Texas 1991, the owner had leased and already transferred 1/2 of 1/8 royalty to kids. 1935, Luckle buys an undivided 1/32 royalty interest, subject to an existing lease, it being understood that grantee shall receive 1/4 of any and all royalties paid under the terms of said lease. All right, so what's going on here? So 1/32 royalty interest, but then it says, well, actually it's 1/4 of any and all royalties. Now again, under the traditional assumption that royalties would be 1/8, that's fine. 1/4 of royalty is the same as a 1/32 royalty interest, because 1/32 is 1/4 of 1/8, right? Multiply those, we get 1/32. Okay, that makes sense. It also provided, however, that the grantee gets 1/4 of any and all royalties reserved under new leases. And so the old lease expired that had that 1/8 term. New leases have that 1/6 royalty. Do we go with what the grant says and say, okay, you still get a 1/32 royalty? Or do we follow the later language in the same instrument that says it's actually 1/4 of whatever the royalties are, because 1/4 of 1/6 is obviously bigger. Since that's a bigger lease royalty, it's actually 1/24. Court harmonizes them and it says, look, Luckle gets 1/4 of royalties. However, because we have this inconsistent language in the grant, if there's ever a lease royalty less than 1/8, still Luckle's going to get a minimum of 1/32. So basically, the court interprets these inconsistent terms and harmonizes them by saying, really, this meant 1/4 of all royalty, but at least 1/32. All right. So what does it mean to harmonize? We have this, and there are different ways the courts have approached it. Obviously, in the Hoffman versus Magnolia, the grant, which was only half mineral interest, and the covers and includes clause were interpreted in different ways. Covers and includes covered all 320 acres of the lease, even though the grant was only for 90 acres. You can have the Concord versus Pennzoil case where we say, look, I think Crosby was trying to give everything he owned, that 1/12 mineral interest, even though he said 1/96 mineral interest. That was just bad draftsmanship. I think they meant a 1/12 mineral interest. Obviously, there's that old rule where we go with the grant, even over the later language and the covered and include clause. So there's a number of different approaches to trying to help the parties out when they have written maybe not what they meant and have written inconsistent provisions into their transfer of leased land.